let's look at which will we're going to build. And there are 4 different choices. Last will and testament. And here come the 4 choices. I can build a mutual will, a simple mutual will, a single will with tax planning, or a simple will without any tax planning. Today, I'm going to build, I'm a single person, my wife has died, and I'm going to, or I've never had a life partner, or I don't really want to give everything to my wife. Whatever the reason is, if I was in a long-term relationship and I was leaving everything to each other, so if I die, I leave everything to my wife, if she dies, she leaves everything to me, I'd do a mutual will. Either one with tax planning or one without tax planning, but I'm not. Either my spouse has died, or I never had a spouse, or my partner's died, or my gay partner's died, or I'm getting a divorce, or I just don't want to leave everything to my spouse. This is the will I'm going to prepare. And it's got full tax planning. It's a tax-effective 3-generational testamentary trust single will. I'm happy with that. Now, I can read a little bit here, but I can actually see a full copy, a full sample of the document with the law firm's covering letter. So let's just have a look at the sample document. When I build my single will, it might be a little bit different because I might answer questions differently. But let's have a look at what happens when you press the sample button, and you will see a sample of the document. And here it is. Now, that logo there is if your accountant, financial advisor or lawyer builds the will for you, they may well put their logo there, otherwise there'll be nothing in that space. There it is, the last will and testament. And this person's decided to have 3 executors. It's fine in the sample document. They're signing on each page. Some hints as well. So this is just a sample. Just give you an idea of what it will look like. We have a 100% money back guarantee, so if you build the will and don't want it or made a spelling error, just email us back for a full refund. There's a Superannuation Testamentary Trust, Clause 9, that washes out all, or seeks to wash out, the 32% or 17% tax on your superannuation or the concessional part of your superannuation. And this person also had everything, contemplating marriage, contemplating divorce, someone's going to challenge the will. These are all questions that will be answered. And even guardians for children. Wonderful. And as with every single document you build at Legal Consolidated, every single document you build on Legal Consolidated's website, you get a covering letter signed by a partner of this law firm, setting out, in this instance, how to sign the will, but whatever area of law it is will have all the legal laws there. And quite a comprehensive letter. And that would be very useful to show to your financial advisor and accountant after you've built the document, signed by a partner. So that's the sample document. Let's now start. Press the blue button to start building the document. Now I'm already a member, so I need to log in, but I don't need to put my username or create a new password or username. And there I've put in my details and I'm now logging in. And I've now logged in and there it is, the big orange button called Single Will Tax Effective, and I can press that. However, if I've already built something for myself or my accountant's built something, I can actually go to other documents I've built and take all that information and put it into the single will. It makes it faster for me to build it. And some accountants might have built you a self-managed super fund on our website, a unit trust, medical power of attorney, enduring power of attorney, now building a will. They've got a lot of data about you. They might just pick up that data and which will then populate the single will. But in my instance, I'm just going to start a brand new single will with testamentary trusts in it. And here it is. I've got all the questions that are being asked on the left-hand side, and I'm going to start going through them one at a time. So I'm going to first put in the name. So I'm preparing a will for Mary Louise Hunt. She's a single person, or her husband's died, or she never got married. Mary Louise Hunt, and that's her date of birth. And here it is. She lives at 47 Lower Fort Street in Sydney. Quite a nice area, actually. So I'm now going to go to see what I've got. Next. So I press next. Now the good news here is I must have answered the first question correctly and filled out the data that the law firm requires, because there's a green tick. That's great news. And I'll move to other names. Now, Louise Hunt may have had a previous name of Smith, so in which case she would put her unmarried name here. But in this instance, she doesn't have any assets in her previous name, so she won't worry about doing that. And she presses next. Now, the age of majority is the age, the minimum age where your beneficiaries can take. Now, if your beneficiaries are all old and of age, or you're happy with 18, then the lowest date you put in, or the lowest age, is 18. And it's already in there, and I'm happy with that. But of course, if you want to have more help there, there's hints everywhere on every single page. There it is there. Who are the trustees of my children at the age of majority, and all those sorts of things. So there's lots of hints there. And also you can telephone us any time. Another green tick for age of majority, I'm doing well. Now we're looking at who are the executors. Now the executors carry out the wishes in your will. Generally, they'll be your children. If you've got children, you leave everything to the 3 children, even if they're only 18 months old or 5 years old, you still appoint them executors. But in that instance, maybe you appoint a couple of extra, an uncle or aunt, in the unlikely event that your children are underage. So I'm going to put Louise has got 2 children, I'm going to put them in now. So there's Louise's oldest child, Jeff Hunt, and I want to add another executor. And so I just press add executor, and we'll put also Louise's second child in as an executor. Now these children may only be 18 months old, they could be 50 or 60 years of age. If they are underage, in this case they are underage, I'm going to put a third executor in, which is a doting and loving uncle. So let's put in Louise's second child. And here is Louise's second child, Joanne Smith. 18 is the age of majority, and she lives at 5 Feathertop Avenue. Now, I don't like abbreviations, so I'm going to put the correct, or we're going to make it Avenue, because I like being exact in the will. And because one of these children are under 18 years of age, I think it's safer to have a third executor who will be an uncle. Maybe you have an uncle, maybe an aunt, maybe a friend who will just do the job until the youngest child turns 18. And there's the uncle, Harry Heppels, who lives in Queensland. Not a problem. So we now have 3 executors, the child Jeff, the second child Joanne, and because one of the children are under 18, we've got Harry Heppels in. Once the children turn 18, Harry Heppels does not need to do the job. He can just renounce at that time if he's still living. So I'm going to go next. And will I get a green tick? Have I answered everything correctly? And I have. Look, a green tick. It's fantastic. Now, Pacific Gifts are evil. They're bad. Always say no to Pacific Gifts. So Pacific Gift, I had a client. He owned a V12 Jaguar, and he left that to his son and $80,000 to the daughter. I said, please don't do it that way. You could sell the car. You get Alzheimer's disease, the kids sell all your vehicles and put you in a retirement home. You don't have any cars. You don't know what you're going to own. The 3 biggest problems of preparing a will is you don't know when you're going to die, you don't know what assets you'll have, you don't know what the tax laws will be. So it's best to say no. In this instance, my client has agreed. He decided to put his car in for his boy and $80,000 for his daughter. We didn't get a chance to review his will again because he died within 3 years of making that will. He had sold the Jaguar. So I went to the daughter and I said, look, your father wanted $80,000 for the car and $80,000 worth of value to you. Because the car's gone, I'd appreciate you giving $40,000 to your brother to make it even. And her husband put his hand on my shoulder and said, Brett, unfortunately, we need that money for our children's school fees. There you have it. Pacific Gifts are really bad. You read the hints, it'll tell it's really bad. You're better to give all the assets equally. You've got 2 children, you're leaving everything equally to the 2 children. Just leave it all equally to the 2 children. Okay, I know you've got jewellery or stuff in the garage. The children will work that out. I know you've got photographs and things. The children will work that all out. So I'm going to say no to that, and I hope you do as well. You can always say yes, but I hope you say no. I'm going to go straight to the residuary beneficiaries. In this case, this client, Louise, has 2 children. She wants to leave everything to the 2 children. So I'm going to put the 2 children's names in here with the percentage. So let's have a go at doing that. So here's the first residuary beneficiary. It's Louise's son, Jeff Hunt. He is getting 50% at the age of 18. I could make that 21 if I wanted to. Or not, I'll make it 21. Boys tend to develop a bit later in life, my mother tells me. And now I'm going to add another residuary beneficiary. So what's the difference between a residuary beneficiary and a specific beneficiary? Well, you don't need to know because you haven't put a specific beneficiary in. But if you have, let me tell you, specific gift is like $100,000 or a car or some shares or something that's finite. Cash at bank. A residuary gift is whatever's left. So I'm giving 50%, whatever I've got left to young Jeff, and now I'm going to give 50% to Louise's daughter. So I now have 2 residuary beneficiaries, Jeff getting 50% at 21 years of age, and his younger sister Joanne getting everything at 18 years of age. She gets 50% as well. I'm now ready to move on to the next question. What will it be? Will I get a green tick? I have. I've got a green tick. Now, the disaster clause is only applicable if you are travelling with the children. So if the children are young and you're travelling with them, it's a potential that you could all die in the same car accident or same aeroplane accident. In that case, you might want to leave half to your mum and half to your dad, or everything to your brothers and sisters. In this instance, Louise is not much fussed about that, so she's not going to put a disaster clause in, and she's going to go straight to the guardianship clause. Now, I'm not going to press next in this instance. I'm going to go straight down here. If I get any crosses here, it won't let me build the document, but I'm okay. So now with guardians, there is a guardian. Let's say that one of the children is under 18 years of age, and therefore I'd like to put a guardian in, and I will put in a doting, loving uncle. I could put in a couple, but I'm just going to put one uncle here as a guardian of the infant children. Now, once the children are 16 years of age, it doesn't make much difference because they may, believe it or not, 16-year-old children don't have to, are not required to live at home if they don't want to, which seems quite surprising. So I have added a guardian. I could add another guardian, but I'm happy with one enough. One is enough. And in any event, in the next 2 years, the child will be 16 years of age, so it won't much matter. Now, considered person clause. Who can challenge your will? This is all about who can challenge your will. Will someone be upset with your will? So the people that can challenge your will, traditionally your parents, people you sleep with, like your husband or wife, lover, gay partner, life partner. Your children you adopt, and commonly stepchildren that you're maintaining, and grandchildren, but generally only if the grandchild has a dead parent or the grandchild's living with you. In this instance, Louise is leaving everything to her 2 children. Considered person clause is not that relevant, but if it was, we'd press yes and we'd put that person's name. Maybe it's an ex-husband of Louise's. We'd put his name in, and all the wording says, and you can have a look at the sample document, all the wording states is that I've given my thoughts to John Smith, and I think I've given him enough throughout his life. So it still means he could potentially, if he can challenge, this clause does not stop him from challenging it, but makes it harder for him to challenge. Now, getting married. If Louise is in a de facto relationship, or she might potentially get married and she knows the person she's going to marry, then she can press yes. Let's say she's deeply in love with Philip Johnson. If she marries Philip Johnson, this will becomes null and void. It's non-operational. But if she puts Phil Johnson in here, then if she does marry him, the will remains valid. If she doesn't marry him, the will is still valid. So this clause is only useful if you know someone that you might potentially marry in the future. Getting divorced. Maybe Louise, look, I haven't got a tick there. I'm getting married. I have to go back to that. That's very good. maybe Louise separated from her husband many years ago, hasn't seen him for years, but if he applies for a divorce 20 years later, or she applies for a divorce, that divorce will invalidate, will render null and void this will. So in that case, she'll put her husband's name in here, or her separated husband's name in there. So if she does divorce him, or he divorces her, the will remains valid. And if she doesn't divorce him, the will still remains valid. What happened about this getting married thing? Why is it not a green tick? Aha, see, I've got yes, and I didn't fill anything in. This is a great system. I'm going to press no. And there I've got my green tick. And I'm going straight to reference. Now what happens with the getting divorced? Aha, lacking another green tick. I better get back to getting divorced. And what have I done wrong? I've pressed yes and not put data in. I haven't put any information in. I'm going to press no, and there goes my green tick. Now, on the second last page is the reference page, and this is commonly, these documents are commonly built by accountants, financial advisors, lawyers, as well as mum and dads. But where an accountant may have 300 or 400 wills that he's done, he may or she may want to have a reference number. So we'll put a reference number in, initials and the client ID. And I'd like that on every page, says the accountant, in case you want to chase it through. And would the accountant like his logo on, or the accountant or the lawyer or the financial advisor, whoever's building stock would like their logo? Yes. Well, this is exciting. I'm now going to press next, and what am I going to get? What's this summary all about? Well, the summary is everything that's now going to appear in the document. So I'm going to check it. Spelling correct. Jeff's, yeah, that's correct. Yes, the addresses look, that's looking good. I'm very happy with that. I've got all the green ticks, and I've got a lock and build. Now, if I have lock and build, it means that I've got green ticks for everything. And here I go. I'm now going to build the document. I'm going to put my credit card details in, and within a few seconds, the document is now ready to be opened. Here we go. I'm going to open the document, and it is saved on your hard drive. There it is there. It's also emailed to you at your email address, and it's also, but 20 years later, you can always log back into our law firm's website and retrieve this particular document. Wow, look what we've built together. How long did that take? Not that long. There's a last will and 3 generational testamentary trusts, so there's got all the tax planning in it, and Superannuation Testamentary Trust to wash out that 32% or 70% tax on your super. Oh look, the references all got in there. That's beautiful. Look at that. More references. This will is made by me, Mary Louise Hunt. My date of birth is 9th of June, 1993. There's the 3 executors. That's Jeff and his sister, who's not yet 18 years of age, but she's still in as executor because she's likely to be in her 60s. And we've got a backup, Uncle Heppels, who'll be one of the 3 executors. But he doesn't have to do the job. He can renounce if he wants, if Jeff and Joanna are of age. And look at that. Everything, I give the trust fund everything to Jeff as a 50% and to Joanne as to 50%. Exactly what they want. Now, in the unlikely event that one of the children dies before you, Clause 5 says whatever the child would have got will go to their children. So let's have a look at this. Jeff has 3 children, many years in the future. It's now many years in the future, and he has 3 children. He's in a car, the car has a car accident, and he's killed. Whatever Jeff would have got when Louise dies, his mum dies, will now go to Jeff's 3 children. Will it go to Jeff's current mistress or his current gay partner or his current wife or his second wife? No. It will go to Jeff's children. It's a bloodline gifting trust. People don't give money to, parents don't give money to the children-in-law. They give it down bloodline. So if Jeff dies, whatever Jeff would have got will go to his children. But the sad news here is that Jeff's car rolls over with his 3 children in it, and all Jeff and his 3 children die, leaving no one left of the bloodline, and therefore, under Clause 5, everything now goes to Joanne. So we've built you a will. We built a will for Louise here that she probably never needs to change again, unless she wants to disinherit one of the children. Bankrupts, protective trusts. This is interesting. Now, we've done enough of picking on poor Jeff. Let's pick on poor Joanne. Now, Joanne has just got married to a very wealthy man. It's a second husband. Louise is 99 years of age, and she gets wheelchaired to the wedding, fantastic multi-million-dollar wedding. She then goes home. 3 months later, she's reading the front page of the newspaper, and it says that Louise and her husband have just gone bankrupt. A petrochemical deal. And from the shock of it, Louise dies. Now, half the assets are going to Louise. And now, with half the assets going to Louise, the trustee in bankruptcy will stand in Louise's shoes and take everything. Well, we can't have that. This is Louise's money. This money doesn't belong to anyone but Louise. So she has the right to put a protective trust, a bankruptcy trust in the will, which she's done. And it says here, if any children are undischarged bankrupts, then I'm sorry, they don't get anything for the 3 years they're bankrupt. They can still be fed some money for education, advancement, support and benefit. That could be $50,000, $60,000, $70,000 a year you can get under certain circumstances. Also tools of trade, all those sorts of things. It's federal law. And when she finishes being bankrupt, then she gets whatever hasn't been spent on her already. Well, that's pretty good. What's this other thing about age of majority? Now, we have one of the children here, one of Louise's children is currently under 18. Well, they can't get the money until they're 18. For the boy it was 21, the age of majority, but for the girl it was 18. She's not 18 yet. Therefore, we've put a maintenance clause in here, a maintenance clause for minors, and that little girl can still get money for education, advancement, support, benefit, and maintenance. So that's not only toilet paper, it's not only school fees, it could even be a car to get to university with. That's pretty good. So we're doing well here. There's the executive's powers. They are designed for one purpose only, to reduce tax. So allowing the two children to manipulate the financial affairs so that they can pay less tax. Clause 8 protects the integrity of the document. So even though some of the laws may change over the years, the gifting to the two children will always remain paramount. And finally, the Superannuation Testamentary Trust. Now, this is not a vacuum that sucks the superannuation into the will. The only thing that controls where super goes is a super fund. So you need to do binding nominations or make sure that your super goes to the right place. If the super gets into the will, speak to your advisor, speak to your accountant, speak to your financial advisor on this. If your super gets into the will, then this has the highest possible chance of washing out that 17% or 32% tax on your superannuation for your concessional component. And Louise did have a child under 18 or under 16, and she's nominated Harry Smith to be the guardian of her children. Not binding at law, but highly persuasive on the courts, and also a very public document. I really think you should do a guardianship clause if and when you have children under 18 or under 16. And there's the covering letter. Look at that, setting out how young Louise, how Mary Louise Hunt will sign the documents, sign the will. And we've done it. We've now built a 3-generational testamentary trust will. Very sophisticated tax planning, and you've done it. Now, that's the first document. There's 3 documents when you do estate planning. The first is your 3-generational testamentary trust will. You also should consider an enduring power of attorney and a medical power of attorney. So a will, POA, and medical power of attorney, and you can build those also on our website. Telephone us anytime. We're a law firm, and we can help you answer any of these questions and give you lots of legal advice as you build this document. Enjoy.